Good afternoon, everybody, and thank you for joining me on this Wednesday. I first just want to give a little bit of an overview about myself before we start jumping into the content for today's webinar. As Brittany mentioned, my name is Nora Ezzat Cozzillio. I am an associate with Tully Rinckey, located in our Washington, D.C. office. I am licensed in D.C., Maryland, as well as the federal courts in each of those jurisdictions and the Fourth Circuit Court of Appeals. I have been practicing labor and employment law for 4 to 5 years now. I have also have experience practicing different types of laws, including human and labor trafficking, family, military justice, sexual assault, and immigration. I did land on labor and employment, which is where I've continued my career to this day. And I primarily practice labor and employment actions on the federal level in the District of Columbia, as well as Maryland. So enough about me. Now let's jump into the content. So I'm sure you're probably wondering what anti-discrimination laws are and how they relate to you as an employee, right? I'm sure you've heard a lot about anti-discrimination. It's kind of a term that you have heard around, but don't quite know what that means, right? So let's go over that. What anti-discrimination laws do is they prevent an employer with 15 or more employees from engaging in any sort of discriminatory conduct that relates to their employment practices, right? So by that, we're meaning any sort of adverse actions that are taken against you, such as poor performance appraisals, demotions, ultimate termination, things like that, things that impact your term, condition, or benefit of employment, right? And these actions are prohibited if they are done with the motivation against any of the protected classes, right? And by protected classes, I mean that it is a definition that was defined under the Civil Rights Act of 1964, which we will get into more in this webinar, that talks about certain memberships or certain attributes of an individual, right? So we're talking about race, gender, religion, sexual orientation, right? Any of those types of things. Now, there are over 20 protected classes that are recognized under the Civil Rights Act of 1964, as well as the Maryland's Fair Employment Practices Act. So there are a lot that are covered. And if any employer takes any actions, like I mentioned, any adverse actions against you as a that is motivated by any of these protected classes, right? That is illegal. And there are lots of things that you can do against that if you feel like you have been treated this way and that it's because of your membership in any of these protected classes. Okay. Now, I mentioned that these were established by the Civil Rights Act of 1964, which I will now go over in our next slide, right? So I'm sure that you have heard about the Civil Rights Act of 1964. It is a huge piece of legislation that was codified by President Lyndon Johnson in 1964. And it governs a lot of the actions that we take against employers today, right? So essentially, what the Civil Rights Act of 1964 established was that there is equal treatment for every American, regardless of race, as it relates to employment, right? And this kind of was piggybacking off of the 14th Amendment in our Constitution, right? That guarantees equal protection under the law, right? So the motivation here for the Civil Rights Act of 1964 was to establish and kind of expand on that 14th Amendment by noting that every American should be treated regardless of race, and obviously that's expanded into other protected classes, right? Particularly as it relates to employment, which is under Title VII of the Civil Rights Act of 1964, right? There's multiple titles under that legislation. The one that we will be specifically talking about today is Title VII, right? Which allows us to take any sort of private actions against employers and protects employees against any sort of disparate treatment. What resulted, again, is the Civil Rights Act as we know it today. On the federal level, that's what we practice when we represent federal employees. We practice under that specific title, and it also provides us additional remedies that we can explore when we take these actions against the federal government. With Maryland, though, right, we still practice under that, right, because the Civil Rights Act of 1964 is a federal law, but Maryland has also instituted their own version of that, which is called the Fair Employment Practices Act, right? So on the next slide, we'll talk about a little bit more about how the CRA influenced that, right? So as I mentioned, it is a federal law, the Civil Rights Act of 1964. So it is enacted across all 50 states. However, some states have decided to enact their own versions of that. Not every state has done that, however. Maryland is one of many that has taken that action, and they have actually created a very versatile and very broad piece of legislation to protect Marylanders against their employers. It is one of the most comprehensive pieces of anti-discrimination legislations in the country. And we'll kind of get into what the differences are between that and the Civil Rights Act a little bit later. But what the Civil Rights Act of 1964 did was make way for these states to create their own pieces of legislation and kind of take that into their own hands and enact what we refer to as double protections, right? Again, we have the federal level with the Civil Rights Act, and now we'll have the state level protections as well, which includes FEPA, right? The Fair Employment Practices Act. One of the main items of the Civil Rights Act of 1964, which is a very important piece of legislation, is that it gave employees a private right of action against their employers, right? So it allowed you to directly make these claims against your employers, right? Where you can now have that investigated by a anti-discrimination agency and then ultimately take that claim and bring it into as a lawsuit, right, in that jurisdiction, right? So that's a really important piece because that kind of builds that framework for the options that you can take against your employer if you feel like they have engaged in any sort of discriminatory practices as it relates to their employment, okay? So the next slide kind of goes over a little bit more of the Fair Employment Practices Act, right? As I mentioned, there is a difference, right? Between a little bit of a difference between the Fair Employment Practices Act and the Civil Rights Act of 1964. And I'll refer to it as the CRA, right? So the CRA, as I said, kind of laid the groundwork for Maryland to enact its own version of that, right? However, there are some, because it's such an old piece of legislation, obviously times have changed and there have been new instances, new items to address, new to protected classes to recognize. So Maryland kind of took that and expanded on that when they established the Fair Employment Practices Act, right? So a couple of things that they did differently that the CRA doesn't quite recognize yet is it provided additional protections for pregnant employees, right? It permits independent contractors, so 1099s instead of W-2s, to also have a right of action against employees. And this is employers, excuse me. And this is very important because, again, independent contractors under the letter of the law are kind of seen as non-employees, right? You're an independent contractor, you can kind of control the method that you complete a task or a project, right? And a lot of times employers work with 1099s to impute their own liability, right? So that they can never say like, well, you were never officially an employee of mine, therefore you can't impute any liability on me, right? It helps them abdicate their responsibility. However, Maryland didn't really feel like that was fair because obviously, if you're still working as a 1099 with somebody, there is a little bit of dominion that they have over, the specific project, and they can still engage in sort of discriminatory practices, right? That doesn't make it, permissible for them to kind of take on these actions and this disparate treatment just because you're considered a 1099, right? Maryland decided to take that step further and recognize that you're still an employee, you're still doing work for them, right? And therefore, you should be able to have your own right of action against those employers, despite kind of whatever tax form you're filing, right? The other item that FEPA and Maryland kind of expanded on was expanding the rights of employees who have been subjected to either sexual and or non-sexual harassment, right? So there's additional protections as it relates to that, right? A lot of what used to be considered the normal type of, or the prima facie case of sexual harassment, right, was anything quid pro quo, right? Maryland has kind of expanded that to say it doesn't necessarily have to be quid pro quo. It can be something as simple as impermissible comments, inappropriate comments made to somebody, right? Anything about their appearance, anything in sexual nature, right? Or even non-sexual harassment, right? Just kind of continuing to target somebody without any sort of due course or reasoning, right? Any legitimate non-discriminatory reason, right? So Maryland kind of expanded that and broadened that definition, which also, again, broadens that protection under the Fair Employment Practices Act. Another aspect that Maryland kind of added on to that as well is it under the Fair Employment Practices Act, they allow employees to bring a harassment claim against employers who only have a single employee, right? As I mentioned previously, under the Civil Rights Act, those protections only apply to employers that have 15 or more employees, right? So this really broadened the scope of individuals who can bring actions against employers who potentially work for small businesses, or kind of, contractors, right? Because now that they can bring that claim against somebody who just has a single employee, right? Again, now they're making sure that nobody is really, immune from this piece of legislation, and that they can't just engage in any sort of conduct, right? Because they fall under that 15 or less employees, right? Maryland allows that to happen against any organization that has just at least one employee, right? Which is a huge win for Marylanders, right? And another item that they also addressed was they removed the minimum age for claims of age discrimination, right? Under the Federal Age Discrimination in Employment Act, right? The minimum age, um, there is a minimum age which is 40 and over, right? Which addresses kind of people who are being discriminated against for being older, right? Who are potentially being pushed out by employers, right? Because of their older age, right? Maryland took that away under their own version of that, right? Where they said that you can engage in sort of any kind of age discrimination. Younger people can be discriminated against as well because of their age, as well as older people. So they took away that requirement because they recognize that that can happen to anybody at any age, right? So as you can see, the Civil Rights Act, again, it laid a very good groundwork for anti-discrimination laws in employment. And it really helped these different states, particularly Maryland, kind of build on that foundation, right? And expand some of these protections, right? Which are great because, again, we have double protections. We have the Civil Rights Act, and now we have FEPA. But FEPA allows a little bit of a broader protection, and a broader scope, and what, employees can what allegations they can bring against their employers as it relates to these specific claims of discrimination. Okay. And in the next slide, we'll kind of go over the fact that FEPA is, as I mentioned, it is a very comprehensive piece of legislation, and it's constantly changing, right? That is one thing that the Maryland legislature does a very good job of, is they're constantly reevaluating newer claims that have been brought by employees, different issues that they see with Maryland employers, right? And addressing the Fair Employment Practices Act in kind, right? As we can see with Congress, things take a lot of time, which is why the Civil Rights Act has very seldom been amended or changed, right? Maryland, luckily, is a very employee-friendly state. They focus a lot of their efforts on protecting employees, which is why FEPA is constantly being revised and amended to broaden those protections, to broaden those claims that people can make, right? So back in 2019, FEPA was amended, right? To one, increase civil penalties with respect to equal pay violations, right? So they used to have it as a statutory maximum, and they moved that statutory maximum so that employees who are claiming equal pay violations can now claim a more advanced and more comprehensive award under that type of claim, right? It also prohibits non-compete agreements for low-wage earners. Non-compete agreements have been a very hot topic within the last couple of decades, right? And one of the issues that Maryland specifically has always had an issue with is how that the scope with which non-competes are applied is unreasonable, right? Particularly as it comes to low wage earners, right? If an employer, if you resign from your position, right, and an employer institutes or enacts that non-compete, right, and they say, well, you can't go work for a competitor that's within 15 miles of us, right, or does the same type of work or something like that. That's really difficult. Maryland has a lot of businesses and employers within the state, and that's not necessarily fair, or reasonable to execute, right, and to enforce against employees, particularly low wage earners, right? And that kind of really prohibits them from being able to find adequate employment, right, elsewhere within the state, unless they have to completely move to a new jurisdiction, right? So FEPA kind of prohibited that and allowed that to not be enforced under the statute, right, or under the legislation. It also, the amendments in 2019 also invoked liability on employers if the harasser, right, the perpetrator, made or recommended any employment decisions against the victim, right? So, what that does is that's a really great piece of legislation that really, again, kind of targets the specific perpetrator, right? And it targets the employer, right, through what we call as like vicarious liability, by holding them responsible, right, for not creating that safe environment for the victim, right? That's really important because typically what happens, right, is, when there's any sort of like harassment claim previous to these amendments, right, it was usually made against that specific harasser, right? What this did was tell the employers, right, you are also responsible because you made this harasser, in charge of making these employment decisions, right? And you permitted this harasser's conduct to continue, right? And by that, you made the environment hostile and unsafe for the victim to continue to work in. So you are just as responsible, right, as the actual harasser and the perpetrator, right? So what that does is it's a little bit of a deterrent, right? It made employers kind of recognize that they will also get in trouble, right, if they permit certain employees to continue to engage in certain conduct, right, harassing conduct that would impute liability on them and make it difficult for them going forward, right? So that was a really great amendment, and it really helped a lot of employees, right, since the 2019 amendments. What it also did was increase the statute of limitations for filing harassment claims from 2 years to 3 years. Now, you probably think, oh, 2 years to 3 years is probably not that big of a change. It is, though. It will take it, right? Additional time to be able to file a claim. You'd rather have more time than less time, right? So it create, having that additional time to be able to make that claim is great for employees, right? Because oftentimes, right, when those things are naturally happening and in the moment, you're not necessarily thinking about filing a lawsuit, right, or making a claim, right? Particularly if you're going through any of the agencies prior to having to file a lawsuit, right, such as the Maryland Commission on Civil Rights or the Equal Employment Opportunity Commission, which I will get to in a moment, right? Those processes can take some time. So you want to make sure that you are not necessarily missing any deadlines while you're kind of going through that adjudicative or that investigative process, right? So having 3 years over 2 years is a great win for employees, right? Who don't necessarily know what they want to do in relation to their harassment claims, right? So that was another great amendment that Maryland made in 2019. Okay. So now that we've gone over, what the Fair Employment Practices Act, is, what it entails, we're now going to kind of go over how you can bring claims under the Fair Employment Practices Act. Okay. So if you feel that you have experienced any sort of discrimination under FIPA, right, which I detail in the next slide, there are certain options that you can take, right? There are certain steps that you have to follow according to the statutes, right, and the rules, but you do have options, right? So first, what the legislation provides, right, which is similar to the Civil Rights Act, is that you can't necessarily bring a lawsuit against your employer, right, right away. You have to do what it's called exhausting your administrative remedies. And by that, it means that you first have to file a claim or what they call a charge, right, with either the Equal Employment Opportunity Commission or the Maryland Commission on Civil Rights. Okay. And these are agencies that specifically take in claims regarding employment discrimination and they investigate them, right? And I will go over that process, but you first have to file with either one of those. You could also do what we call a dual filing, right? Which, you file with both the Maryland Commission as well as the EEOC. And essentially what happens there is whichever agency has the capacity to take on your case first, they take that first, right? It's a process that we sometimes recommend if clients are kind of want this to be processed a little bit more fastly, right? Or if they want the investigation to kind of be conducted a little more quickly, right? Because it guarantees that whoever is basically available to take it, they take that first, right? So again, the selection of either agency, because while they are the same in their goals, their processes are just slightly different. And that is kind of dependent on your overall goals, your timing, and your resources, right? So, with the Maryland Commission on Civil Rights, they are a state agency that takes in claims that only exist within the state of Maryland, right? So, it can only be employees that work within the state of Maryland. Whereas the EEOC takes in claims that are both with the state of Maryland as well as on the federal level, right? So, they take in claims with private employees, right? As well as federal employees. So, what I say by thinking about your goals and your ultimate, the timing and things like that is sometimes with the EEOC, they can take a little bit longer to kind of go through that investigative process because they just have a larger caseload than the Maryland Commission on Civil Rights, right? So but, again, if you are more interested in kind of filing with a federal agency rather than a state one, if that's kind of your goal, you feel like that maybe can, pack a bigger punch, right? Then that's something to consider as well. Again, it really depends on kind of your specific objectives, your goals, what you're looking for in terms of a resolution, that kind of thing, right? Regardless, you don't, like I said, you don't have to pick both of them. You can just pick one. And again, it is dependent on kind of what you're looking to achieve. But you do have to select at least one in order to kind of go through that administrative process. And then potentially at the end, if necessary, be issued your right to sue letter and then be able to bring your claim against your employer in a court of original jurisdiction. Okay. So as I mentioned, there's a little bit of a difference between how the Maryland Commission on Civil Rights and the EEOC handles the processing of their charges, right? And in the next slide, we'll talk a little bit more about MCCR specifically, right? So as I mentioned, that is an independent agency within the state of Maryland that investigates claims of discrimination and harassment, right? Not just with employment, with housing, public accommodations, health services, leasing of commercial property, that kind of thing, right? And it specifically enforces Title 20 of the state government article of the Annotated Code of Maryland, right? Now, that's a lot of legalese. What does that mean, right? As I mentioned, the EEOC kind of operates on the federal level, right? So they enforce the Civil Rights Act of 1964, right? What Maryland Commission on Civil Rights does, since it is a state level agency, it enforces Title 20 of the state government, which is the Fair Employment Practices Act, right? So they, while they take in as well as the Civil Rights Act of 1964 claims underneath that, right? Where they are specifically working off of is Maryland pieces of legislation, which is Titles 20 of the state government article, right? So that's a little bit of a difference so far between the Maryland Commission and the EEOC. Now, as it regards to the MCCR filing process, right? The next slide has an infographic that kind of goes over what this process looks like, right? So MCCR, what you first do is you submit something that's called a preliminary questionnaire, right? And it's very simple. You just go on their website and you fill out this form that is on there that's called the preliminary questionnaire, right? And it asks like some basic questions, right, about who you are, who your employer is, right? What position you were in, what your claims are, right? The specific, they're going to ask for specific incidents, regarding any sort of discrimination, retaliation, harassment, that kind of thing, right? And it will be detailed enough for them to be able to kind of make a determination whether they have jurisdiction, but it's not going to be so exhaustive at this point, right? That's what the intake interview is for. So what the next step does is determine the jurisdiction, right? They want to make sure that through that preliminary questionnaire that, obviously you were an employee working within the state of Maryland, that the employer also is operating within the state of Maryland. As I mentioned, they can't take claims from, anything out of state, right? They can't take a claim from a Virginia employer, for instance, right? So they have to make sure that they have jurisdiction to be able to investigate your charge, right? So once they make that determination, say, you are within the jurisdiction, right? The next step is you will be contacted by usually what's called a specialist, right? To schedule what they consider an intake interview. Okay. And during that interview, they will kind of go over your preliminary questionnaire, right? They'll get more information from you, right? This call can last quite some time. right? Because they're going to be asking more specifics. They're going to ask a lot of different details, names, dates, individuals involved, right? Locations, that kind of thing, right? Because what they do at that time, after the interview is conducted, is they draft the charge for you. Right. So once they get all of that information during the interview, right, they will go ahead and they'll draft the charge, and they will put that together, and then they will send that to you, right, as the charging party, right, um, to review it to make sure that they have all of the facts and the details correct, right, and that if you approve of that, right, and everything is correct, then you sign that, right, and you send it back to the specialist, who will then finalize that and send that to the responding party, which is the employer, right, for their review, right? What happens after that is the responding party or their employer has an opportunity to review all of the allegations that have been lodged against them, right? And they get to put their response together and submit that back to the investigator, right? In what's called a position statement, right? And a position statement is essentially as it sounds. It's the responding parties, statement on their position, their response to the allegations, right? Which is usually they did nothing wrong, right? As always, they will provide any sort of rebuttal evidence to your allegations, right? And they'll say, this is our position, this is what we're relying on for our position, this is what we have to demonstrate our position, that kind of thing, right? So they will put that together. They usually have somewhere between 30 to 60 days to do that, right? They can request an extension if necessary from the investigator, but it's usually within 30 to 60 days that they'll submit that position statement to the investigator, who then can send that to you afterwards, right? So on the next slide, we'll kind of go over the additional kind of case processing, right? So once that position statement has been submitted, right, to the investigator, right, your case then officially begins an investigation, right? So that investigator will do that initial case review and kind of go over anything. Sometimes they will reach out to you, the charging party, if they have any specific questions about your charge, right? Any additional information that they're seeking, right? They'll do the same with the responding party, if they have any kind of, clarifications that they're seeking, anything like that, while they're putting together this investigation, right? They might ask for documents, they might ask for, witness statements, anything like that, right? So, they kind of go through this. And then, as they're kind of doing this, as I mentioned before, the position statement from the responding party will be provided to you as the charging party. Okay. And what you will be able to do at that time is provide a rebuttal or a response, right, to the position statement. So they'll give that to you. They'll say, this is what the responding party had to say about their position. You will have, between 30 to 60 days, right, to provide your response or your rebuttal to what they're saying, right? So you'll be able to go through their position statement, refute any things that they're claiming, any of the evidence, or supportive documents that they have submitted with that. You'll be able to kind of go through that as well and kind of refute that or clarify or anything like that, right? And then you'll be able to submit your response to the investigator, who will then review that, right? And kind of go through that and add that into their investigative materials, right? During this period, where, after you've submitted that, the investigator will be completing their kind of what we call like the final case review, right? So they're going to be evaluating all the materials that they have that has been provided to them at that time, right? And they will be able to kind of, help that make their determination on whether they want to issue some sort of finding or not, right? So after that, the investigator will issue either a written finding, or they'll issue the right to sue letter, right? So there's three different options that can occur after this time, right? So we'll go over the first one. The first one is they issue a written finding. And they say, based off of everything that has been presented to them, right? They have found that, whatever the claim is, discrimination, retaliation, harassment, right, that did exist in this case, right? And therefore they suggest that the parties either kind of you try to work that out, right, through either some mediation or something like that, and they can provide some sort of mediators, right, to kind of determine some informal resolution, right? And usually, like I said, they recommend that the parties work together to find some sort of resolution, because otherwise, you will be able to kind of sue them in court, and you'll have this written finding, right, to support your allegations, right? You will say, I went through the administrative process. This is what I was issued. They even found that there was a finding of discrimination, harassment, retaliation, whatever it is, right? And you'll be able to submit that with your lawsuit, right? Another option that is given is that they don't have a written finding, right? Which doesn't necessarily mean that they're saying no discrimination or harassment or retaliation existed, but it's usually is saying that they weren't given enough materials to be able to say that definitively, but they will still issue you the right to sue letter, right? Or you can now bring this case to a court of original jurisdiction, right? And continue adjudicating this in a court of law, right? So that's an option. That is the one that we typically see the most often, right? We don't always have MCCR or the EEOC make an issue a written finding, right? That there was discrimination or harassment that occurred. And that, again, doesn't necessarily mean that they didn't think that there was any kind of any mistreatment or misconduct. What it usually means is that they just don't have enough documentation, or they weren't able to procure enough supportive, evidence to really say that definitively, right? A lot of times that happens if, the responding party, the employer is not being very cooperative throughout the investigative process, right? They're only kind of being minimally compliant. They're only kind of providing enough information, right, to show that they're being cooperative with the investigator, but they're not necessarily producing everything, right, that they have within their possession. And they don't necessarily have to at that time either, right? They're not in discovery or anything like that. So usually that's kind of what, influences, that kind of determination, which is saying we can't say one way or another, but at least you're still able to have recourse after that, right? You're still able to go to court, you're still able to file a lawsuit against them. You'll have this right to sue letter, which you'll have to file with your complaint, right, to show you exhausted your administrative remedies, right? So you'll still have an opportunity to kind of move forward with your matter. You just won't have that specific finding saying, yes, we determined that there was discrimination, or yes, we determined that there was harassment, that kind of thing, right? So that's one of the second option, right? The third option is that, MCCR or the EEOC will issue, a no finding letter, right? Which basically says, we cannot find any instance of discrimination, harassment, retaliation, right? And therefore we are closing this charge, right? If you want to appeal, you have 30 days to do that, right? To appeal the decision. And you have to do that with the EEOC, right? And they'll kind of, in that letter, they will lay out the appeal procedures for you to do that. And you have to kind of reiterate your charge and appeal their findings, right? Present additional documents to show why they were wrong in dismissing it, that kind of thing, right? That one is a little bit more rare to see. That's really in cases where, usually the charging party hasn't presented enough documentation to prove their allegations, or to at least demonstrate their claims, right? But typically that one is a little bit more rare. I've seen that on very fewer occasions, right? Because we make sure that when we're filing charges, right, on behalf of our clients, we're putting together a very comprehensive packet to submit to MCCR. So that's why that's kind of a little bit more of a rare occurrence. Okay. So those are those steps for the MCCR. Okay. Now, going on to the Equal Employment Opportunity Commission, right, on the next slide, the process is very similar to MCCR, right? You will file a charge, right? It'll be assigned to a case specialist who might do an intake interview, gather additional information, that kind of thing, right? What the Equal Employment Opportunity Commission does really well, right, in my experience, is that typically when these charges are initially filed and they're kind of going through that initial processing time, they are very heavily handed in suggesting mediation, right? And mediation is a fantastic resource and it's a fantastic step to take in the resolution of your charge, right? And mediation essentially is, going, having both all parties, right, meet together, typically virtually, right, with an assigned mediator from the commission, right, who is usually, again, it's someone that's not related to either of the parties, right, where they kind of help engage in that conversation to see what each party is kind of looking for and resolution of that charge, right? You'll usually have, usually on the responding party side is their attorneys, right? Potentially maybe a representative from the actual organization itself, right? And then on the charging party side is usually you, as well as any representative, legal representative that you might have to help you throughout that process, right? And again, it's really a very open conversation, where the parties join together, figuring out what they want. You'll be able to present kind of your opening statement, right? Where you'll talk about what brought you to filing the charge, what you experienced, and what you're looking for in order to resolve your charge, right? And sometimes the responding party will also make an opening statement. Sometimes they don't. Sometimes they'll want to just immediately go into what's called like a caucus, right? Like a breakout room with the mediator to talk about your settlement demand, right? Your demand for closing out your charge, right? And kind of going over what their counter offer is and that kind of thing, right? After that, the mediator will then come to your caucus, right? Your breakout room, which is usually you and your representative, to kind of talk about those options, see kind of what, how you're feeling about it, what counter demand you want to make, right? Or if you want to accept their counter offer, things like that, right? I always recommend mediation, right? As a first step to resolving a charge. Like I said, I think it's a great, fantastic step. Even if the parties aren't necessarily able to resolve the charge in that moment or kind of reach an agreement, you still walk away from that mediation with more information than you had before, right? You have more information about the responding party's position, what they're relying on for that, right? What they're thinking in terms of a resolution or a settlement, right? And it can at least help you make additional informed decisions about your next steps, right? Either the parties are too far apart in their positions that settlement is probably not an option, or maybe you guys are close enough that what it's going to do is going to take a little bit more time for you guys to continue to have those discussions to ultimately reach an agreement, right? Mediation isn't always successful in that moment in time. Sometimes those conversations have to continue after that meeting, right? Via email and stuff like that, as people kind of sit with the options and think about what they want to do. And in fact, I think most of my mediations get resolved after the fact, right? After I'm able to kind of speak with their representative and kind of work out how we can kind of reconcile our the differences, right? Particularly in our positions and our offerings, right? But it is a really great step. And if both parties are interested in engaging in it, I think that that's fantastic and it should be pursued, right? Because with the EEOC, mediation is not mandatory. It is an option, right? So both parties have to be interested in doing that. They can't be compelled to engage in mediation. So like I said, if both parties are interested in going and participating in mediation, it's usually a great sign. And it's definitely one you kind of want to jump on, right? To see if you can resolve the charge, right? So like I said, the EEOC's process to MCCRs is really, really similar. Again, they're very heavy-handed in recommending mediation, right? That's a little bit of the difference there. But the process is really the same, which is kind of outlined in the next slide, right? Which is you submit the charge of discrimination to a local office, which is usually the Baltimore office, right? Engage in mediation, if applicable, as I mentioned. If not, right, if neither party wants to engage in mediation, it will just continue to be processed through an investigation where, again, the responding party will file a position statement within 30 to 60 days. You'll be able to review it, provide your rebuttal, your refutations, that kind of thing, right? And then the investigation continues. And then at the end of that investigation, typically you're issued your right to sue letter. Okay, so very similar. In terms of which is better, right? Filing with the Maryland Commission or the EEOC, right? The next slide kind of goes over those, right? So as I mentioned very early on in the webinar, It really is dependent on your goals and your objectives, right? Either of these processes can take time, right? The statutes provide that they can take up to a year to complete their investigation, sometimes a little bit longer, right? They'll seek an extension of time to complete the investigation in some instances, right? It depends, like I said, it really depends on how cooperative parties are being, right? How many other investigations that investigator has. Sometimes there's a transfer of investigators during that process, right? And if investigator leaves, right, or something like that, it has to be assigned to somebody new, and that will take them time to get caught up on it, right? So it can be a long process, right? So that's always something to keep in mind. Is that what you want to do? If you want something that's a little if you want to make sure that you're not spending as much time right on that, or you want a little bit more of an efficient or expeditious process, we do typically recommend the Maryland Commission over the EEOC, right? As I mentioned before, because they are a state agency and they don't take on federal complaints as well, right? Obviously their caseload's a lot smaller than the EEOC's, who does both. And they typically just, like I said, are run a little bit more efficiently. They can kind of more expeditiously go through that case processing and that investigations, right? So we typically recommend going with Maryland Commission on Civil Rights. We understand why people want to file with the EEOC. As I mentioned, it's a federal agency, kind of packs a big punch, right? When, that responding party gets that charge of discrimination, it says, your former employee has filed a charge of discrimination against you with the Equal Employment Opportunity Commission, right? It's a little bit of a gut punch. So I understand that kind of strategy. But you just have to understand, that might take a little bit more time, right? And if you have time, great. If that meets your goals, fantastic, right? But you have to just kind of consider which one you want to do, what that means in terms of your objectives, and kind of, what you're hoping to achieve in the end, right? Both of them will still exhaust your administrative remedies, right? Reaching a settlement is still, a possibility, right? With either of those processes. As I said, EEOC is a little more heavy-handed in terms of them recommending, mediation, or kind of, really pushing for that and encouraging it, right? So if you're hoping to maybe file the charge to ultimately go through mediation, maybe the EEOC is a little bit of a better option for you because they encourage it so heavily. But there's also the option of doing a dual filing as well, as I mentioned previously, right? You can do a dual filing where you're basically, when you file that charge, it gets filed with both agencies at the same time, and whoever is available sooner to take on your charge, they'll grab that, they'll start processing it. That way you feel like you're kind of having a little bit of a two-pronged approach, right? So again, both of them will meet your objectives in terms of exhausting your administrative remedies and things like that. But, in terms of which is better, that's kind of a conversation you should have with one of our attorneys, to kind of talk about your specific goals, and what we can do to help you achieve those goals. Okay. Right. And now I think we have a couple pre-submitted questions that I want to go over. Right. And if we have time, we'll have additional, questions that have been presented in the chat box. Right. So one of the questions that we received, as a pre-submitted question was, a breach of employment contract, and, what remedies you have for there. Right. So that's a really interesting question, right? And I'll give you the answer that my mother hates that I say, which is it depends, right? Because there are employment agreements out there, right? That kind of govern the relationship between an employer and an employee, right? And kind of outlines those expectations for both parties, right? Generally, though, again, Maryland is an at-will jurisdiction, right? Which means that both an employee and an employer can, separate at any time for any reason, with or without cause, with or without notice, right? Maryland does not allow people to kind of be bound to each other in employment, right? Because that creates a lot of other ethical issues, right? We don't want people working in roles where they don't want to work anymore, that kind of thing, right? So, When you say like breach of an employment contract, that's really going to have to be a little bit more specific. Like what exactly was breached, right? Was it, a benefit that you were supposed to have while you're in employment and it was never, that you never received that, right? Was it, any sort of like confidentiality breach, like from the employee to the employer, that needs to be explored a little bit more in depth, right? And that's actually a really good, question to ask if you ever wanted to book a consult with one of our attorneys to talk about them a little bit more specifically, because like I said, there's lots of different contracts out there with many, many different terms, right? So it's hard to be able to say, if you have any remedies for that, right? Particularly if it's dependent on a specific term, right? If even different industries have different things that are considered, like boilerplate for, like the tech industry that's different for like the education industry, right? So that's definitely a more specific question to ask if you ever wanted to book a consult with one of our attorneys. Okay. Just what is about discrimination against special needs employees? That's a great question, right? So that might fall under what's considered disability discrimination, right? And FIPA has its own version of the Americans with Disabilities Act, right? They have their own section about discrimination against anybody with a disability, right? So if you have encountered any sort of discrimination based off of your disability, right, your recognized disability, both under the ADA as well as FIPA, right? You might have a claim for that, right? If you require special accommodations, right? In order to complete your job duties and things like that, and they either denied it or have ignored your request, right? Or have refused to properly accommodate, those types of things, right? Those might be claims as well. So luckily FIPA does cover that as well. And again, double protections. We have the ADA and we have FIPA, right? So those are also claims that you could potentially pursue depending on what the actions were taken. Okay. Um, okay. So how do you handle being terminated? But they use the phrase restructuring to justify your termination because you complained about unfair wage practices. Okay. That's also a really great question, right? Complaining, let's break it down though. Complaining about unfair wage practices or anything like that might be considered like a whistleblower protection, right? It also depends on who you complain to. Did you complain internally to them, right, to your organization and your employer? Did you complain, or file like a complaint with like an outside agency that would investigate it, like Maryland's Office of Inspector General, right? Those types of things. We'd have to learn a little bit more about that. But being terminated, with the company giving you the reason that they're restructuring or it's a reduction in force or something like that, we see that a lot, right? Particularly right now. And unfortunately, that happens quite often. In order to kind of refute that claim, right, and to show that your termination was indeed wrongful, right, and it wasn't related to any sort of legitimate non-discriminatory reason, we need to kind of have a little bit more information about that, right? If you feel like it was related to your complaint about unfair wage practices, right, we need to kind of evaluate, okay, well, were they aware that you complained about it? Which kind of goes back to my initial question of, did you file internally, right? Did you go outside of the organization and file it with a state agency, right? They have to have some knowledge about the complaint in order for us to properly be able to assert that your termination wasn't related at all to any sort of restructuring, but was in fact retaliation for a complaint that you made. Right. So again, we have to be able to demonstrate that there was some knowledge on their behalf for them to have taken that action against you. But fantastic question. How long does a discrimination case take to settle? Another great question. Again, it depends, right? It depends on what route you go, right? If you ultimately file, a charge of discrimination with the Maryland Commission on Civil Rights or the EEOC, right? Again, as I mentioned before, there's a lot of different opportunities during either of those processes to settle the case and kind of either go through mediation or just have general informal discussions with them, right, about how to settle. If you choose to not necessarily go that route and you want to potentially just negotiate directly with the employer, right? Via something like a demand letter or something like that, right? That is also something that changes that trajectory, right? Typically, on an average basis, right? negotiating directly with an employer doesn't take as long as going through the charge of discrimination, right? Because you're having those direct discussions with the employer, right? You're not involving a third party or an outside agency to either mediate those discussions or kind of go through that investigation process. But if you're asking how long the investigation kind of takes, right, from start to finish, from when you file that charge of discrimination to receiving your right to sue letter, it can be really honestly anywhere from a couple months to over a year. Right. I have seen some cases where the investigation has been wrapped up pretty quickly and, a client has been issued their right to sue letter, sometimes in 6 months. I've also seen it take over a year, right? If there's either backlog of cases or an investigator's been reassigned to that case and they have to get caught up, right? Again, I'm sorry to say it depends, but it does, right? Okay. Um, Another question that we have is what is the difference between unfair treatment and discrimination? And that is a fantastic question, right? Um, as we say oftentimes, right, the law is very specific about what they consider to be, discrimination or harassment or retaliation, right? Unfortunately, having a bad boss or a bad manager is not really illegal, right? And as much as we would like that, we've all had bad bosses and bad managers, right? But not everything that they do is illegal, right? So it has to be very specific. So in terms of, discrimination, right? If you're wondering if your manager or your supervisor is engaging in any sort of discrimination, right? What we look for is, are you a member of one of those protected classes, right? Race, gender, sexual orientation, religion, that kind of thing, right? And are they treating individuals who are not members of that same class better than they're treating you? Right. That's a really good way to determine whether you feel like you're experiencing discrimination, right? Or you're a victim of discrimination, right? Unfair treatment, right, is a little bit more of like a broad term. Like, are they just not being nice to you? Or, they just kind of like, do they just not like you? Because unfortunately that's allowed, right? You have that's a little bit more of, are they just kind of a bad manager, right? Are they, you know, they don't approve your PTO time, right? Because they need you for an assignment. That might not necessarily be discrimination, right? If they need like coverage for that day, right? It might just be very unfair and not great, obviously, but it may not necessarily be considered discrimination, right? But of course, if you have any like specific questions, give us a call and book a consult with us, and we'd be happy to chat with you a little bit more specifically about your specific claims. Okay. Okay, and what is considered retaliation, hostile work environment, employees based retaliation, what laws apply? Okay, so retaliation is, any sort of adverse actions that are taken against you because you disclosed something or you reported something, right? And the legal term of art that's really used here is called like protected activity. Okay, and what that means is that you engaged in activity or you made a disclosure or something that is considered protected under the law. By protected, we mean you can't be retaliated against or receive any sort of reprisal or adverse treatment because you made that disclosure, right? So, filing an EEO charge of discrimination, right? That's considered protected activity. Filing a whistleblower complaint if you feel like your employer was engaging, in like misappropriations or prohibited personnel practices or anything like that, or discriminatory hiring practices, things like that. If you report that either, internally, right, or externally to an outside agency, right, and your employer finds out about that and they want to silence you, so they're retaliating against you, right, or they're trying to force you out, that kind of thing, that's considered retaliation, right? And if they're making that environment also hostile for you, right? And by hostile, I mean, you're constantly being targeted, with harassment, negative comments, right? There's micromanaging that's been established. They're starting to take duties away from you, right? Things like that is considered like a hostile work environment, right? And all of those actions fall under both the Civil Rights Act of 1964 as well as the Fair Employment Practices Act for Maryland, right? So again, if you have any specific questions about anything that you've experienced with that, definitely give us a call and book a consult. We'd be happy to talk about it more thoroughly with you. Okay. So I think we just got a couple questions in the chat that I want to ask for. Um, do you find that a lot of employers refuse mediation? Great question. I, I would say probably it's around like 50-50 in my experience, right? Not all employers want to engage in mediation. That doesn't necessarily mean that they don't want to ultimately have those settlement discussions, right? Or explore settlement, right? Like I said, oftentimes the agreements that I'm able to reach in my cases usually happen offline outside of mediation, right? Where we're able to kind of continue that conversation. I sometimes am able to kind of reach out to, their legal representatives to kind of have that discussion, if even if they do refuse mediation, right? Because I at least want to explore whether they they are interested in kind of settlement. And usually, when I'm able to do that, I'm able to have a productive conversation about how to resolve the claims, right? So even if they do refuse mediation, there are still other ways to explore settlement, right? And kind of, evaluate whether there's an opportunity for everyone to kind of informally resolve it, right? And sometimes it can be as easy as a phone call with opposing counsel. Sometimes it's not, right? It really kind of depends on the claims and kind of their position and what they're relying on for it, right? Which we usually have a better understanding of when we're able to kind of review their position statement, right? And we can kind of assess whether mediation is still something to pursue or, something like that. But, in my experience, they don't always engage in it, but I still am usually able to find some way to kind of engage in those settlement discussions with them. Okay. And I think that is, oh, we have one more. How long do you have to file a charge? Great question. Lots of great questions today. In terms of being able to file a charge, right? So typically under the EEOC, right, you have 180 days to file a charge. It's called a charge of discrimination, right, against your employer. Because Maryland has enacted FEPA, right, its own employee protections, right? That deadline extends to 300 days, right? So again, the double protections there also give you additional amount of time to be able to file your charge of discrimination. And when we calculate those deadlines, we're looking at the last action that was taken against you, right, with your employer. So, for instance, if you were terminated yesterday on May 13th of 2025, in Maryland, right, and you want to file a charge of discrimination, you will have 300 days from May 13th of 2025 to file that charge of discrimination, right? Now, that is a lot of time in the law, right? On the federal level, for instance, if you're terminated and you want to appeal that, you have 30 days. So it's a lot of time in private sector, right? That doesn't necessarily mean we want to take all of that time, though. You obviously want to file sooner rather than later, right? And make sure that you're one meeting that deadline, and also, trying to get ahead of that long processing time, right? So that you can get some sort of resolution more quickly. But no, you will have 300 days from the last action, right? The last discriminatory action. And it is calculated beginning on that day, and then you add 300 days from there. Okay. So great question. But thank you all for joining us today. It was a pleasure. Maryland employment law is I'm very passionate about it, born and raised in Maryland, right? So if you have any questions, definitely reach out to us. Our contact information is on the screen. If you want to book a consult with any of our Maryland attorneys. But otherwise, thank you again, everyone, for joining us today. And I hope you have a great rest of your day and a great rest of your week.